Hello, everyone, and welcome. My name is Sam Alba. I am president of the UB Law Alumni Association's Gold Group. Thank you for attending today's CLE presentation, New York State Appellate Practice for the New Year. This is one in a series of many virtual programs the Law Alumni Association and Gold Group are hosting as a service for our alumni and law students. If you are interested in attending other upcoming webinars and CLEs, you can register at the UB Law School website, law.buffalo.edu/alumni events. You can also listen to past CLE and other webinar recordings at no charge on our new alumni education webpage, also located on the law school website. To get discounts and select a free 1-hour CLE, please consider becoming either an annual or lifetime member of the UB Law Alumni Association. We throw great parties. Rob's usually there. It's a lot of fun. Finally, I'd like to thank the Gold Group sponsors who have helped underwrite the costs associated with these events. Those sponsors are Chicago Title, Counsel Press, Equitable Advisors, Jack W. Hunt and Associates, and Precision Resolution LLC, also known as Paramount Settlement Planning LLC. Now, a few brief administrative points. You will be muted during the course of the presentation. If you have a question at any time, please use the chat room. We will try to address the questions cumulatively at the end. At some point during the course of the CLE, the course code will be announced and will also be placed in the chat room. I have been specifically instructed to not read you the course code right now, even though I know what it is. Follow the rules here. Please be sure to catch it, as you will need to put it on the online attorney verification form that was included on the registration page. This form is required to issue you your CLE credit, so please make sure you return the course program evaluation form found on that page. Without further ado, I'd like to introduce my friend and colleague, Earl Cantwell.
Hey everyone, like Sam said, my name's Earl Cantwell. I'm a graduate of the law student and co-chair along with Emily Rudroff of the Education Committee of the Gold Group. It's my great pleasure to introduce our speaker today, is Rob Bricado. Rob opened Counsel Press's Buffalo office in 1992, and he's managed it continuously since then. During his more than 30-year career, he's been personally involved with thousands of appeals, primarily to the New York State Appellate Courts and United States Court of Appeal for the Second Circuit. Rob serves as vice president on the University at Buffalo Law Alumni Board. He also serves as co-chair of the Bar Association of Erie County's Appellate Practice Committee, and he's a former director on that organization's board. Rob is actively involved with multiple legal organizations and associations in the upstate New York region, and he's presented CLEs on appellate topics to legal associations throughout the state. We really thank Rob for doing the presentation today, and he's free to begin whenever he's ready.
All right, thank you. Thank you, Earl. Thank you, and thank you, Sam. Let me just share the PowerPoint here. All right, well, thank you everyone for being here today. Thank you for the introduction, Earl, and Sam as well. I'm glad to be able to present this program today, and I see a lot of familiar faces that were signed up too. So Counsel Press is the nation's premier appellate support services firm. We have been in business since 1938. As Earl had mentioned, I've been with Counsel Press. This is my 30th year. Actually, no, going on my 31st year. So as of April, we work in all the federal circuits, all 50 states. We have offices across the country, and our main office is in New York City, but we also do our production in Rochester. We have our print office in Rochester where our production is done. We offer same-day service in most courts, in all New York State courts, and in federal court as well too. We also, I should mention too, we have a legal writing and research department as well, which is available if anyone ever has a need for that. So there's a lot of information we're going to cover today. I'm going to try to focus a little bit more on the fourth department and the third department, and I think those are what attendees you're probably practicing in most of the time. I'll touch on a couple of points at the first and second that are really kind of unique and need some elaboration, but it's a lot of information. I'm going to try to focus on issues that we see at the fourth department and in the other departments as well, but sort of problem points that do come up often, and I want to spend a little time on those. So we're going to cover the electronic filing requirements of the appellate division, statewide practice rules. We're going to look at some of the individual department rules, brief look at rules of practice for New York State Court of Appeals, and then we'll have questions and answers. Okay. So I've said this to many people, but as of March of 2018, when the e-filing rules took effect and the New York State statewide rules took effect as well, that has changed the area of appellate practice in New York State considerably. It's a lot more complicated than it used to be, because you're now, not only are you looking at e-filing rules, you have to also look at the statewide practice rules, and you have to look at the individual department rules too. Each department has their own rules. So the statewide practice really aren't uniform rules. There are a set of rules that each court follows, but there are so many differences still by each department. You kind of have to juggle all three sets of rules. So this took effect March of 2018. So e-filing at the first and second department, actually for all four departments, at this point, just about every case is an e-file case. And when I say e-file, I mean e-filed through NYSEF. That's one point, that even if it's not a NYSEF e-file case, the court still wants digital copies of every filing for a record or brief. So even on the rare case where it wasn't, you still had to upload a copy through a digital portal. So first department, it's mandatory. The only exception is original special proceedings and attorney matters. And I'll just make them, as you see on the PowerPoint there, COVID-19 really accelerated the mandating of e-filing. That's why at this point, just about every type appeal is e-file. Second department, all appeals originating in Supreme or Surrogates Court and e-filed in the court of original instance. That's an important difference there. It had to have been an e-file case at the court below there. So we still see a number of non-e-file cases at the second department. Third department, all appeals are e-filed except original proceedings and attorney matters. And actually, I believe they just instituted original proceedings as the first this year too. So at this point, everything at the third department would be. Fourth department, it's mandatory on all appeals, order of transfers, and special proceedings. The only point is, though, with the orders of transfer, even though the rules say it's mandatory, the court's not set up for it yet. So if it's a transfer proceeding, it's still done without going through NYSEF. And that was effective as of April 1st, 2021. So why would you intend to perfect an appeal or seek a reversal? Why would you take an appeal? Either if you intend to perfect the appeal or seek a reversal. There's a potential to perfect the appeal also if you're unsuccessful on re-argument or renewal motion, or you might be filing a notice of appeal to bluff or to help facilitate a settlement. The notice of appeal is always filed at the court of original instance. So when you're filing an appeal as of right to the New York State Court of Appeals, you go back to the county court and you file it at that lower court. You don't file it at the fourth department or the department level. You file it at the original instance court. Filed within 30 days after the order or judgment is served with notice of entry. If it's served by mail, you do get an additional 5 days. It's pretty rare to see that now because most cases are through NYSEF. Cross appeals, it's 30 days after the order or judgment is served with notice of entry, or 10 days after the notice of appeal, whichever is longer. You file the notice, you should include an order or judgment appealed from. Fourth department is going to be looking for proof of service of the notice of appeal. Even though it's filed through NYSEF, you should still provide the fourth department proof of service, and I'll get to that. There's a confirmation notice you can print out that shows that. There is an informational statement. This is used in the first, second, and third departments, but not in the fourth department. It's in the material that I provided. There's a lot of information and forms in the material that I provided. And then there's a filing fee of $65. So the reason why there's no informational statement for the fourth department is because that document really pertains to settlement and pre-settlement programs. So you don't have to really worry too much about the specifics on the informational statement. It's a form, and sometimes it can be hard to be as specific as you want. It's really just there for settlement purposes. And since we don't have a settlement program at the fourth department, we don't have to worry about that form. So what e-filing did was it basically added a second layer of filing after you file the initial notice of appeal at the court of original instance. Within 14 days after you file your notice of appeal, you should upload the notice of appeal to the appellate division, and you're essentially creating a new NYSEF docket for the appeal. And then you're going to get assigned a case number or docket number. So this is all a whole series of steps that had never been required before. I think many firms have caught on to this, most have, but we still see a number of situations where these steps were never taken. So you're supposed to do it within 14 days. It's not a jurisdictional deadline. So if you're late, it doesn't matter. You haven't, it doesn't affect your appeal. And if your opponent is late, you're not going to get anywhere by making a motion, or there's something you can do about it. But you want to take those steps. You upload the notice of appeal through NYSEF to the appellate division. The appellate division then issues a docket number. Downstate, they call it a case number, but it's the same thing. Fourth department usually sends the docket number to you very quickly, usually the same day. They'll also send to you a form called a notification of case number. When you receive that email with that form, you then want to serve a hard copy of that form on the other side. It has to be hard copy service. And then you want to upload proof of service to NYSEF. And you have 7 days from when you get the notification of case number to serve that notice. And then when you upload the proof of service, when you've served that form, your adversary has 20 days to register on NYSEF. And that deadline is really key, because if you're the respondent on an appeal and you miss receiving that notification of case number, if after 20 days after you were served it, you're deemed accepting electronic service. And I've seen cases where the respondent is unaware that the appeal is perfected because they never registered on NYSEF. I've seen where these have come down to the oral argument and the respondent wasn't aware. And if you haven't submitted a brief by the time of the oral argument, you can't even appear on the case. So you want to make sure to look out for a notification of case number if it's served on you. You want to make sure that you register. And in fact, it's a good idea if you're served a notice of appeal, if you know a notice of appeal is coming, you want to make sure that you look out for that notification of case number. Because with mail today, if they serve it by mail, since it's a hard copy serve, you might not get it, and that it has serious ramifications. So that's really something important to be aware of. So when you log on to NYSEF to file the notice of appeal and create the appellate docket, you're going to go under File Documents to the link where it says Appellate Court, and that'll then take you to a series of links. And then you answer a number of questions, and then you upload the notice, as I had said. It's fairly straightforward. But if there's issues or questions, you can reach out to me, but you can also reach out to NYSEF as well. So for purposes of timeliness, an e-file document is deemed filed when it's electronically transmitted through NYSEF, the filing fee is paid, and it's filed by 11:59 on the deadline. Any confidential information should be redacted before it's e-filed. If it's confidential documents pursuant to an order or a statute, when those documents are filed, my office would normally upload the order making the documents confidential, and then they are saved on NYSEF in a way that precludes public viewing. And you have to attest to the usual compliance with statutory redaction and sealing requirements. So an original with ink and 5 copies are filed within 2 business days after the court approves e-filing. That's, however, was modified. These are for record and brief. It's an original, and for 4th department, it's an original and 2 copies. For 3rd department, it's an original and 5. 1st department only has 2 copies, and 2nd department is not requiring paper copies at all right now. So, like I say, it's all across the board. It's different all across the board. We anticipate that it's very possible the 2nd department at some point might want hard copies. That court is about 2 years behind on calendaring cases, so we can't tell, but it wouldn't be surprising if, as some of these cases come up for oral argument, they might request hard copies. Okay. Now we're going to move on to the statewide practice rules. I don't know if there are any questions in the chat, or if you want me to wait till the end of the program, Earl, or?
There's no questions as of
Okay.
yet.
All
I'm
right,
keeping an eye
great.
on it though. I can let you
Okay.
know.
It's a
what's
lot of
going
material, so I don't mind taking a break at moments like this. So.
Oh, we do have one here.
Okay.
I download. Oh, it's about the materials. Never mind. Not for you.
Okay. All right.
Do you want me to let you know? If you pause again, I can let you know if there's anything.
Yeah. There'll be other pauses, so
Okay.
that's fine.
Sounds good.
So perfecting an appeal, you're going to have 6 months from the date on the notice of appeal. That's a change from how this used to be in the 4th department. We were the only department that went by the date of service of the notice of appeal. So you're now going by the date the notice of appeal is dated, and it's a completely arbitrary date. So this can catch you up if you're not aware of it, because usually they're filed the same day, but sometimes you date a notice of appeal and then you don't file it for a couple of days. Your timing goes when you dated it. So make sure to be careful for that. Prior to the 6-month deadline, you can extend time by 60 days and then an additional 30 days. The 1st department has a special program going right now. If it's an interlocutory appeal related to discovery issues, you only get 4 months to perfect. We just had an appeal from Buffalo where that was the case. That's the first one I'd seen of that. So it doesn't come up that often, but that's just the 1st department. Before your time is expired, you can then request also 30 days. And then anything beyond that requires a motion. 4th department has been pretty good about granting a motion beyond the 2 letter requests, as are most of the departments. The only one where I understand it's not always a given is the 2nd department. This is one area where, if for some reason you had neglected taking those e-filing steps and you never uploaded your notice, when you're getting ready to file for an extension, you're going to have a problem, because you're then going to have to rush through that set of steps that we had discussed regarding e-filing, because you won't be able to file a request for an extension unless you have a docket set up on the appellate division. So we see that happen. It happens a lot, but it's that's why you want to make sure to get that done as soon as possible. So after 6 months or an ordered on date, if you don't perfect, the appeal is dismissed. You can vacate dismissal by motion. It has to be made within a year of dismissal. And you basically just have to show intent to perfect within a reasonable time and reasonable excuse, which it's really, you don't have to, it doesn't have to be, don't have to elaborate too much. You do have to show merit. You have to have at least a paragraph that shows merit in the appeal. I had somebody once who attached their brief. You would think that would be show merit, but they got to reject it because it didn't show merit. You have to have it specifically in the motion or in your affidavit as a part of the affidavit. They're usually granted. 4th department especially. I've never seen where they didn't grant one unless, like I said, it was rejected for failure to show merit or something or some sort of particular regarding the motion. And then you can usually file it again if for some reason it is rejected. So methods of perfecting, there's the full record method, the appendix method, agreement, discrete statement in lieu of record, and an original record. So I'm going to spend most of the time talking about the full record method. We do not see the appendix method done much at the fourth department. The reason is, if you're going the appendix method in fourth department and third department as well, you still have to prepare a full record. Fourth department lets you just digitally file that record. Third department wants a hard copy of the record. But just the act of preparing a full record and then preparing an appendix, which is going to be a part of the record that's relevant, it creates a lot of extra work. The only time it's really cost benefit would be if it's a very voluminous record and it's on your appeal is on a very narrow issue. Otherwise, there's a lot of extra work involved. You're essentially creating two documents with different pagination, different contents. So we don't see it that much at the fourth department. Third department, you see it on criminal appeals more so, family court appeals, because the court's a little more, they're very open to it there. But even there, you don't see it much other than on those type cases. It's very different downstate. First and second department are very strict about the certification of the record. If you're filing an appeal at the first or second department, you need to include everything identified in the order, everything that was before the judge. Even if there's motion sequences you're not appealing, you still need to include those documents if they're cited to or were a part of the case. So you can, in that court, it's advantageous to use the appendix method. There you're able to subpoena the record, so you don't have to produce a printed record and then file an appendix of what's relevant to the appeal. So you see the appendix method done frequently downstate. As for the original record too, there are cases that are listed in the rules, statewide rules, that call for original record. At the same time, though, at the fourth department, we don't see this that often because most of those cases, they're either not common or criminal or matrimonial. The court has separate procedures for them as well in their rules. And a lot of times it's just easier to just prepare the record on appeal as opposed to going by the method that's in the court rules. I'm not going to spend too much time on that, but if anybody has any questions about that, please feel free to reach out to me. There's basically rules in the local rules that allow for appendix method for family court appeals and criminal. Essentially, you can use that and go that route, or you can do a record. It depends on how much of the lower court docket is relevant. So for the full record, motion practice, if it's from a motion, you want to include the 5531 statement. That's going to be, we usually put that now at the first in the beginning of the record, which is actually what the rules call for. Also a notice of appeal, order of transfer, order appealed from, notice of motion, affidavits, any replies. And then if it's a judgment after trial, in addition, you're going to include the trial transcript, any certification or stipulation of order settling the transcript, and I'll get to that too, and any trial exhibits that are going to be included. So as far as certifying the record and appendix, for the fourth department, it was always required that you stipulate to the record pursuant to CPLR 5532, or have an order settling the record from the lower court judge. We were never allowed to certify the record at the fourth department. And what that means, certifying the record, is pursuant to CPLR 2105, and it's where an attorney certifies the record without contacting the other side. And that was never allowed at the fourth department. It was practiced at the first, second, and third department, but under the statewide rules, you're now allowed to do so. And that's now done very commonly. So that can cause problems if something is missing from the record or if something is in the record that shouldn't be in the record. So I'll get to that as well, but that was certainly a big change. There's a lower court rule in the fourth department rules. I'm sorry, there's a local rule in the fourth department rules that says that if there's any dispute as to the contents of a record, it has to go back to the lower court to be resolved. And that's for the fourth and the third department. And that addresses that issue. If there's a transcript in the record, if it's trial testimony, sworn testimony, or you need to stipulate to that transcript if you're not stipulating to the record. This is new at the Fourth Department because we've never had certification. So it only kicks in if there's sworn testimony. And in that case, if you stipulate to the record, you've covered the transcript. You don't have to worry about stipulating to the transcript. But if you're not stipulating to the record, if you're planning on certifying the record, you need to settle the transcript. You need to essentially, it's pursuant to CPLR 5525, you send out a copy of the transcript with the proper notification, which is in the information as well. Your adversary has 15 days to get back to you. And if they don't get back to you, then you file an affirmation of compliance in the record saying that these steps were taken. This is new. We never had to deal with this because records always had to be stipulated to. So if the record is stipulated to, it's understood the transcript is correct. If you certify and you've got one of those transcripts, this is something that you should be doing. Exhibits can be omitted by stipulation. And then memoranda should not be included unless they have independent relevance. So, and that can be, that could be questionable if it's independent relevance or not, but we sometimes see them in, sometimes we don't. So the supplemental record, this is where I get to if you have an issue to the record after it's been perfected. So if your adversary perfected the appeal and they certified it, and they never reached out to you as to the contents, and it's missing documents that should be in the record, the way to proceed would be with a supplemental record. And in order to file a supplemental record, you're going to need the other side to stipulate to file it, which doesn't seem right, since they can certify the record and then they omit something. You have to get them to agree to include the document in a supplemental record. But that the court doesn't allow certification of a supplemental record. The alternative, if the other side refuses to stipulate to include a document that you feel should be in the record, you have to go back to the lower court, make a motion to settle the record, settle the supplemental record, and then get that order and include that in the supplemental record. I've only seen that done a couple of times. Usually parties are willing to stipulate to supplement the record, but that's the alternative if they will not do so. So this multiple appellants, this is an area that causes a lot of confusion. So I'll spend a little time on this. There are cross appellants and there are concurrent appellants. Cross appellants are an appellant who's adverse to you. So if you're thinking about if you're planning on filing a response to the lead appellant's brief, you're going to be a cross appellant. If you're all on the same side, if you're not adverse, you're concurrent appellants. And it's important because this affects the timing and it affects the way the briefs are filed. So regardless, whether you're cross or concurrent, all appellants share equally the cost of the record. And this is all part of the changes that took place in 2018. So cross appellants, any party can choose to be the lead appellant. Whoever decides to take the lead on the case is the lead appellant. They perfect the appeal. They go based on their notice of appeal, the timing from their notice. Every party has their own deadline. So if the lead appellant decides to file for an extension before they perfect their appeal, chances are that's going to affect your timing as well, because most notices are filed around the same time. So as another appellant on the case, you're going to also have to extend your time if they extend their time. Their extension doesn't affect you. You have to be responsible for your own timeline. This comes up all the time. And if you don't extend your time, you might find out when it's time, when the appeal gets perfected, that your appeal was dismissed because you didn't perfect it within 6 months. So each party is responsible for extending their time. You can, like I said, you can get the 60-day extension and a 30-day extension. The respondent is then going to, the lead appellant perfects the appeal. The respondent is then going to respond with their responding brief and include their cross appellant brief in their responding brief. So chances are, even if the appeal is perfected within 6 months and no time is requested for an extension, while you're going to get 30 days from when it's perfected to file your response, your time to perfect your appeal is going to probably have expired by that 30 days. So if you're a cross respondent, if you're a respondent cross appellant, you're probably going to have to extend your time as well, even if the appeal is perfected within that 6 months, unless it's perfected early. So concurrent appellants, this is where you're not adverse to each other. The notice of appeal, these are notices of appeal from the same order. The latest deadline is the deadline by which you have to perfect. And all the parties, all the appellants have to perfect together, meaning you have to perfect the same day. So the court, if they receive the record and it's filed early, and one appellant brief is uploaded and the other one isn't, they'll send it back. And you'll have to wait until you get all the appellate briefs in on the same day. And this can be a hassle, like it seems like it would be. And you've got, especially if you've got multiple appellants, trying to get everybody together to file on the same day. And you usually end up waiting till the latest day. We had a case recently where one of the appellants wanted to file months ahead of time because they wanted to get the case heard. And they had to wait till the case was just about ready to expire because they had to wait till all the appellants were ready. So these have been major changes, and they've made the rules a lot more complicated than they ever were before. So between the statewide rules and the e-filing rules, it's just made things, it's really changed the way appeals are perfected in especially the fourth department. These rules tend to reflect how things were always done at the second department. And the second department is the busiest court in New York State. So they kind of, we kind of feel like this was done so that things are along the lines of how they do things. So if you have multiple orders and they're consolidated, if it's from the same index number, they're consolidated as of right. So you don't need to make a motion to consolidate. If they're from different index numbers, you do need to make a motion to consolidate. But one other point, if it's the same index number and you're trying to consolidate, if it's a different appellant on each of them, you cannot consolidate automatically. So if the lead appellant files their notice of appeal, cross appellant only appeals on the second order on the index, on the same index number, you can't consolidate automatically. It's got to be the same party appealing on both orders within the same index number. And otherwise, you need to make a motion to consolidate. So brief requirements, main briefs they allow up to 14,000 words, reply briefs, 7,000 words. The font is 14-point proportional font or 12-point monospace font. Footnotes should be 12 or 10 points, depending on if it's proportional or monospace. We never see monospace, so it's basically 14-point proportional and 12-point footnotes. There shouldn't be any bold or all caps except in the argument headings. And the first department doesn't allow any emphasis at all. So you can't even italicize or underline there. Table of contents and table of authorities are required. The printing specification statement goes at the end of the brief, and that basically says the font and the point size, and it's just some information that the court requires as far as the brief. The last point there is also, that's a major change at the fourth department. The fourth department used to pretty much allow you to attach anything to your brief. The court accepted it, and they left it to the other side to make a motion to strike it if they felt it was inappropriate. They are now only allowing documents that are decisions, statutes, rules, or ordinances, like the PowerPoint says, anything that's not readily available. They will also still take documents that are in the record on appeal if you want to highlight it. That's something that the court always, the judges always preferred. So that's still allowed. But you can't add something outside of the record. They consider that expanding the record. It won't be accepted by the court. So as far as
I'm sorry to interrupt you, Rob. Can we just stop and do the
sure.
course code quickly?
Sure.
The course code is appeals, and I will also put that in the chat. We did have one question, Rob, about the materials. They're asking if the PowerPoint would be available.
Sure.
I didn't see
Yes.
it, but we can always add it later if
Yeah.
you want to do
Oh,
that.
yeah, absolutely.
Okay, great. Thank you. And again, the course code is appeals, and I'll drop it in the chat as well.
Okay, so the brief timing. First department, this is something unusual with them. They follow a term calendar. I'm not going to go too much into detail of it, but I'll bring it up later when we talk about local rules. So they're completely different than the other three departments. Otherwise, though, respondents, second, third, and fourth department, you get 30 days after the last appellant's brief. Well, actually, respondent second and third department, it's 30 days after the last appellant's brief. Fourth department is the only court that allows you to file a response to each appellant brief. So a respondent can file a brief. If there's multiple appellants, they can file separate briefs to each appellant. You don't see that often, but you do see the reverse, where you're filing a reply. Fourth department allows you to file a reply to each responding brief. You don't have to file one brief. The other departments all require just one brief be filed. So that's why for the second and third department, you would file after the 30 days after the last appellant brief was filed. But fourth department, like I say, it's 30 days after the appellant brief is filed. You can respond to each appellant brief, and you can reply to each respondent brief. Reply briefs 10 days after the last brief filed. Yes, there's a mailbox rule for non-NICEF cases. Like I say, it doesn't really come up much at the fourth department. And we cover the respondent brief with multiple appellants. So respondents can extend time by letter for up to 30 days. They can do that twice. They can also do it by stipulation, but really, there's no reason to not just do a letter. It's much easier. Reply briefs 10 days twice, and anything beyond that requires a motion. So in-person oral arguments, all the courts right now are in person. Fourth department did institute a pilot program just starting in February. It goes through May, where you can opt to do a virtual appearance as opposed to in person. The fourth department also, even though you're requesting oral argument in your on your brief cover, they'll contact you when the case is coming up for argument, and you have to opt at that time to either appear virtually, in person, or to just submit. So this is the only department that's allowing virtual appearances at this point. So we'll see if that continues beyond May. Settlement or withdrawal of an appeal. So if you haven't perfected the appeal yet, but you've initiated it on NICEF with the appellate division, and your appeal ends up not proceeding, you should file a letter withdrawing the appeal if it's not proceeding. As far as if the appeal is perfected, then the parties do need to stipulate to withdraw the appeal. And you should do that as soon as possible. Always notify the court of any sort of change as soon as possible. If you fail to do so, you can face sanctions at the second department. And I'll just mention this. I had done a program with the Bar Association back in October with the fourth department, and the chief clerk and Flynn had mentioned, this is something that really the court does not like, when they get late notification that a case has settled. I mean, if it settles at the last moment, well, there's nothing you can do about it. But if you know about this in advance, let the court know right away, because the court spends a lot of time preparing for the oral argument. So that time then ends up being wasted if they could have avoided it if you knew the case had settled. So make sure to contact the court as soon as possible if a case settles. So, any questions? Okay. All right. So I'll just talk briefly about some of the local rules in each of the four departments. First department rules. The first department goes by a term calendar, and I'm going to get to that on the next slide. Everything is scheduled according to a calendar. And all arguments are in person as of September of 2021. And hyperlinking to cited authorities is now optional at the first department. Second department requires hyperlinking of every authority in your brief, and it's now optional at the first department. So there's a good chance that that's going to become mandatory at some point. So this is the appellate division calendar for 2023. So the way this works, essentially, if you were to perfect your appeal, let's say by the next upcoming date is January 30th for the April term. If you perfect the appeal by January 30th, then the respondent is going to be due on March 1st. And the reply is due March 10th. And then your argument is going to be starting March 28th, which even though it's the April term, it starts March 28th. So if you file early, if you were to file your appeal between January 3rd and January 3rd, you filed it early, it doesn't affect the amount of time that you would have as a respondent. Your deadline is March 1st. So you file early, you give your adversary extra time to respond. And so you may have more than 30 days in which to respond as a respondent. And then the same happens with a reply brief. If you file the response early, the appellant has extra time to file a reply. You've got till March 10th. You can extend time if you're perfecting the appeal the same way as in the other departments. You can ask for a 60-day extension by letter, and then you can ask for a 30-day extension. But if you're responding or replying, you can't ask for 30-day extensions or 10-day extensions on reply. You have to stipulate you can stipulate to up to a 7-day extension without moving your case to the next term. And if you are moving beyond the next term, you can do that too, but you're going to have to stipulate then to adjourn the case to the next term. I don't want to get too much into this because it can get really complicated, but just be aware if you ever have an appeal at the first department, especially if you're responding or replying, the rules as we have them in the other departments for extensions don't apply. You have to follow the calendar system. And that calendar then it helps move the court along, but it's something it's just very different as far as the timing. So I won't go too much into detail, but if anybody has any questions, please feel free to reach out to me. But just so you're aware if you're dealing with that court. Actually, when I started at Counsel Press, fourth department used to have a term calendar too. It wasn't anything as elaborate as this, but they actually, at the fourth department, if you had filed on a certain date, you knew you were going to have your appeal argued on a certain term, which they eliminated that like back in the late 90s. So that shows you how long I've been doing this, but it's they actually did used to have that too. So the second department requires that all briefs be prepared in digital format, contain bookmarks linking every entry in the table of authorities, in cases, statute, and other authorities, to where that authority appears in the brief, and either to the authority itself, or it has to be attached to the brief, or a hyperlink to Lexis or Westlaw. So it's great for the court. Any case you're citing to, they'll click on the link and bring up that case. It does make the process much more involved for the second department. Right now, they're the only department that requires it. The first department allows it, and like I said, they may end up requiring it, and we may see this required someday at the fourth department. I know Mark Bennett, the former clerk, he had told me he really didn't want to see that happen, but it's as the court moves to more of a heavier focus on digital filings, it's just natural that they're going to want the best digital product that they can get. And this is going to be more convenient for the judges, but there's no discussion of it yet, not that I'm aware of, but just be aware downstate this is required, and maybe someday at the fourth department. So third department, there is the initial information statements required, but not on unemployment or workers' comp cases. And as of the first of last year, those cases were put on NICEF as well. So like I said, just about everything really is. Hard copy of a motion is still required at the third department. So if you make a motion for an extension of time, you do it through NICEF, you still need to send a hard copy to the third department. They're the only court that requires hard copies. The appendix method, we covered this. You need one hard copy of the record as well. And it's a 6-month deadline. Special proceedings are all sorts of special proceedings at the third department. It's a 6-month deadline on those as well. And original proceedings are filed under special proceeding rules. So fourth department, we've covered a lot of this, but the fourth department doesn't require the initial information statement. There's no settlement program. Motions that are not subject to e-filing are uploaded through the court's digital portal and served electronically if that's accepted by the parties, or hard copy. Unfortunately, we don't see too much of non-NICEF cases anymore at the fourth department. And except on appeals where poor person status is granted, color covers are still required for the briefs. Appellant petitioner blue and respondent red, reply gray, amicus green. And they do want the cover, when you do the upload of the brief, they want the cover to be colored as well. Scheduling orders are issued after the appeal is perfected. Rebuttal is not permitted. The scheduling order gives you the 30 days that you're entitled to for the respondent brief. Post-argument submissions are not discouraged. Statewide rules say that they're discouraged, but the fourth department has a local rule that says they're not. This court encourages them. And if it's a NICEF filing, the rules say that you need an original and 5 copies are required. That's not the case. The court doesn't want any hard copies on the post-argument submissions. You have 5 days to submit a post-argument submission from the argument. It's best to get it in right away as soon as possible, because sometimes the court's already deciding cases before those 5 days are up. So you want to get it in as soon as possible. It has to be a letter. You can't submit a brief. It's got to be a letter format, and it just gets uploaded through NICEF. We'll talk a little bit about motion practice. Motions are served. You have to still provide at least 8 days notice before the return date. Include the notice of appeal and order at issue. The fourth department wants proof of service of the notice of appeal. So if it's a NICEF filing, which it usually is, attach the confirmation notice that you get when you file the notice of appeal. Returnable Mondays, 10 a.m. It really hasn't changed too much. The one difference is it has to be filed by 4 o'clock at the court. You want to make sure to upload the motion by 4 o'clock on the day it's due. And the same with opposition papers. You want to make sure to upload them by 4 o'clock. And you can adjourn by stipulation for 7 or 14 days. A motion to re-argue or leave to appeal can be made within 30 days of service of the appellate division order with notice of entry. If you never serve the order with notice of entry, your time never starts to run. But you want to make sure that you check the NICEF file from the court below as well, because you might be served the order with notice of entry through NICEF. So that starts your clock running. Re-argument motion, you need to show points misapprehended or overlooked by the appellate division, and the motion has to state the questions that are to be reviewed. And it's not guaranteed a reply, but if you time for reply, but if you do have time, the court will accept it. So I'll move on to the Court of Appeals. Just kind of a brief overview there. So appeals as of right to the Court of Appeals under CPLR 5601 and 5611, most common are where there's a double dissent or if there's a constitutional question. The other 2 points, judgment absolute, or the other point, last point there, where dealing with finality, you don't see them very often. Usually it's a double dissent or a constitutional question. 1.2, if it's not a final determination, you cannot make a motion for leave to the Court of Appeals. but you can make a motion for leave to the appellate division to the Court of Appeals. So you can't make a direct motion to the Court of Appeals from a non-final decision, but you can make a motion to the appellate division for leave to appeal to the Court of Appeals from a non-final decision. So appeals by permission, final determination from the appellate division that's not appealable as of right, and you're seeking review of the appellate division's prior non-final order after a final judgment. You can, as I said, make two motions generally if it's a final decision. You can make a motion for leave to the lower court, I mean to the appellate division, and then to the Court of Appeals. So you can't extend time on filing a motion for leave, but if you're in a situation where you really need more time, you can at least make a motion to the lower court, being the appellate division, and that'll give you time then until they make their decision, and then that decision served on you with notice of entry to prepare your motion to the Court of Appeals. It's rare for the Fourth Department or for any appellate division to grant leave to the Court of Appeals. So in a way, if you really need more time, get a motion in quick to the appellate division, and that way at least you preserve your time, and then put your effort into the motion for leave to the Court of Appeals, if that's presuming it's denied. And I have seen some recently that were granted, so they do get granted by the appellate division. If it's an issue that they feel that they want the Court of Appeals to address, they'll send it on to them to be resolved. So your timing is 30 days from service of the judgment or order appealed from with notice of entry. And if you're moving directly in the Court of Appeals, 30 days from the date of service of notice of entry of the denial of the motion made to the appellate division. But you have to be served the order with notice of entry. If you're not, you can serve it yourself, or in your motion, you can just address the fact that you were never served at all. So in the motion, you want to include the notice of motion. You can do a memo as well, but it's not necessary. Statement in support of the motion, which must detail the chain of timeliness. So you have to show that you're timely, either within the 30 days of service of the order with notice of entry, or just say that you were never served. If corporate disclosure as well, if it's applicable, and then you want to attach to the motion the order, the appellate division order with notice of entry, and any order relevant from the courts below too. It's an original copy and two hard copies that are filed at the Court of Appeals, and you have to serve one hard copy. And the 30th day, when you're trying to calculate when you need to file your motion for leave, that it just needs to be served by that deadline. It doesn't need to be actually at the court. So that gives you that extra day. You don't have to calculate time to overnight it to Albany. It just needs to be served by the 30th day. And there's a $45 filing fee made to the State of New York Court of Appeals. So once that's done, the court will then send a letter which will give you a PIN number and a motion number. And then the electronic filing is then done. It's not submitted through NYSEF. It goes to the courts. The Court of Appeals doesn't work with NYSEF. They have their own e-filing system, Court Pass, but you use Court Pass when you're perfecting an appeal, not when you're filing a motion. So there's a companion portal for filing digital copies at the Court of Appeals, where you file then one digital copy of the motion and a digital copy of each of the briefs and of the record. It's just like everything else. Nothing is as simple as it used to be. So the e-filing has made it more complicated. You've done a motion for leave at the Court of Appeals. So no reply papers are permitted, and there's no oral argument on these motions. And it can take months. There's no way to predict how long it's going to take for a motion for leave to be granted or denied. The font size is the same as for the appellate division. It's 14-point proportional font, 12-point monospace. It's essentially the same, no bold or all caps, double spaced. So if you have an appeal as of right, and what you're going to do is you're going to file your notice of appeal at the lower court, and then the court of original instance. And then within 10 days, you're going to submit a preliminary appeal statement to the appellate division. And the same as if it's 10 days after the motion for leave is granted. That's submitted to the court. There's a form in the book. There's also a form on the court's website. That's the one document that the court is usually lenient about. If you're beyond 10 days, they don't enforce that strictly. And I think that's it. So that is it. So if I didn't cover, if you are granted leave and you're taking an appeal to the Court of Appeals, it's going to be, they still require 10 copies of the record and brief be filed, and you have to serve 3 copies on the other side, each of your adversaries. So that's the one court where there's still a lot of copies that are required. And in fact, it's less than it used to be. It used to be even more. But it's all, those are filed through Court Pass then at the appellate division. The Court of Appeals. And it's if you're not registered on Court Pass, you should register. Usually your attorney number and login will work, but you should set up a Court Pass account. It's nice to have because you can access all the documents through there. It's similar to NICEF. It's just their own system. So thank you. That's the end of the program, and I'm just about on time. It looks to get through this all within an hour.
It looks
All
like
right,
we do have one
everyone.
question.
Oh, we have a question.
Yep. It is, can you refresh our memory on the definition of double dissent?
When there's two parties who are two judges are when there's a split, when it's a split decision where there's 2 justices who rule, 3 in favor, 2 against. That'll be a double dissent. So if you've got a split decision, then it's an appeal as of right. That's the
Okay,
decision
great.
from the appellate division.
Thank you.
So our time has now expired. I hope everyone wrote down the super secret key code, which is, again, appeals, not apples, appeals. I'd like to once again thank our speaker, Rob, for his time and his insights, and all of our sponsors for making this possible. Everyone, please be sure to send in your attorney verification form and program evaluation form to Michelle Miosi so that we can issue you your CLE certificate. Thank you very much and have a great day.